So imagine Adam Savage coming in here with Mythbusters plausible. Like, so you've gotten to the end of the thing, and is it myth confirmed or myth busted? It's plausible, somewhere in between. That's really the only standard that we're here on a motion to dismiss. If it's plausible, then the thing goes forward. If it's not plausible, then it doesn't state a claim, and therefore the motion to dismiss gets the thing dismissed, and that's what's happened here. So why?
This is a community-supported legal education channel. Find out how you can support our mission at the links in the description below.
It looks like Gigi Hadid has won her copyright lawsuit. I don't even know how this is possible, so join me as we look at the Eastern District of New York. This is exclusively a really funny kind of pun of a name there. Since it's a pun, does that mean it's not trademarkable? Go watch our video. It's not how that works. So Exclusively has sued Jelena Nora Gigi Hadid, who is a world famous supermodel, probably one of the most popular or highest paid supermodels in the world. And this is the judge's memorandum and order. You might remember that Gigi was sued by Exclusively. Remember, she's the defendant, because she posted their photograph on her Instagram, and then when she was confronted with the plaintiff's claims, one or two of her defenses were she posed for the photograph and therefore assisted in its creation and therefore has some kind of applied license, or she cooperated with the photographer and therefore she's part of the creative input and has some kind of ownership of a copyright or at least a license. I called out their law firm for making frivolous arguments that really can't even sustain a motion to dismiss themselves or motion to strike themselves. But that's not what ended up being what got the lawsuit dismissed. Let's take a look at the judge's reasoning. January 28th of this year, Exclusively commenced this action against internationally famous supermodel Gigi Hadid, who maintains an Instagram account with more than 43.7 million followers. Because this is a motion to dismiss, the court accepts all well-pled factual allegations in the complaint as true. That means the judge is assuming, just for this purpose, that the plaintiff's allegations are true as long as they are well pled. And then, even if true, is there still a dispute over whether this complaint really holds any water, is legally sound, etc. So if there's any tremendous or egregious technical defect or factual defect in the case, this is one of the reasons why you would bring a motion to dismiss. On January 28th, plaintiff commenced the action alleging that it is the copyright holder and owner or licensee of a photograph, which was the subject of a valid and complete application before the United States Copyright Office for Certificate of Copyright Registration by the Register of Copyrights at the time of the complaint being filed. Plaintiffs allege that defendant did not have a license or permission from plaintiff to post a cropped version of the photograph on her Instagram account when she did so on October 12, 2018. The complaint advances a claim for direct copyright infringement, contributory copyright infringement under the Copyright Act. On April 10th, the court granted defendant leave to file a motion to dismiss, which was fully briefed June 7th. To survive a motion to dismiss, a complaint must contain sufficient factual matter, which, like I said, we accept as true, to state a claim, a legal claim for relief that is plausible on its face. So imagine Adam Savage coming in here with Mythbusters plausible. Like, so you've gotten to the end of the thing, and is it myth confirmed or myth busted? It's plausible, somewhere in between. That's really the only standard that we're here on a motion to dismiss. If it's plausible, then the thing goes forward. If it's not plausible, then it doesn't state a claim, and therefore the motion to dismiss gets the thing dismissed, and that's what's happened here. So why? In order to establish a claim of copyright infringement, a plaintiff with a valid copyright must demonstrate 1, the defendant has actually copied the plaintiff's work, and 2, the copying is illegal because a substantial similarity exists between the defendant's work and the protectable elements of the plaintiff's work. To survive a motion to dismiss based on a failure to state a claim, a plaintiff bringing a copyright claim must generally plead 1, specific original works which are subject of the copyright claim, 2, that plaintiff owns the copyrights in those works, 3, that the copyrights were registered in accordance with 17 U.S.C. 411, and 4, the acts by which and the time period during which the defendant infringed the copyright. And so you can sort of see where we're going here. If you remember, we did a video about Fourth Estate versus Wall-Street or wall-street.com, and that was where the court talked about the same thing. The registration requirement. Assuming without deciding that plaintiff has sufficiently pled that it owns a valid copyright, the court concludes that plaintiff's copyright infringement claim should nevertheless be dismissed due to plaintiff's failure to comply with the registration requirement. As the Supreme Court has held, the registration requirement is a statutory condition under which a plaintiff must obtain registration of a copyright in a work before filing a lawsuit based on infringement of that work. The relevant provision provides that except for an action brought in violation of certain rights, 106A, which are the moral rights, which we often don't talk about, and we very rarely see lawsuits about that. And the subject of provisions of Section B, which is, I don't forget what that is, but we'll maybe put a link or something over the video as an exhibit. No civil action for infringement shall be instituted until pre-registration or registration of a copyright claim has been made in accordance with the title. Here, plaintiff does not allege that it has been formally granted registration of a copyright in the photograph from the Copyright Office at the time it filed the complaint. So it's not even a matter of we can wait for registration. The court is saying that the legal requirement is you must have a valid registration, not just an application, before you even file the complaint. And since you didn't do that, goodbye. You are the weakest link. Goodbye. Let's see. Under these circumstances, the Supreme Court's recent decision in Fourth Estate, Public Benefit Corp v. wall-street.com, a case interpreting the registration requirement established in Section 411, forecloses plaintiff's direct infringement claim. In Fourth Estate, the Supreme Court rejected the position that a copyright owner effectuates registration when it submits the application, materials, and fee required for registration. It instead held that registration occurs only when the Copyright Office grants registration. Acknowledging the holding in Fourth Estate, plaintiff argues in effect that because it filed the complaint in this matter before the Supreme Court's decision, and because prior to Fourth Estate, the Second Circuit had left the application registration rule issue to the discretion of the individual judges, Fourth Estate should not preclude plaintiff's infringement claim. The court disagrees. There is no doctrinal basis or no precedent on which this court can decline to apply a Supreme Court decision that would otherwise apply merely because the Supreme Court decision was issued after the filing of the complaint at issue in the case. Indeed, plaintiff cites no case law supporting its position. In Fourth Estate, the Supreme Court decisively held that Section 411A requires a plaintiff to have already been granted registration from the Copyright Office prior to commencing an action for copyright infringement. Although Fourth Estate post-dated plaintiff's filing of its complaint, it is nevertheless binding on all lower federal courts unless and until the Supreme Court decides to revisit it. See Marbury versus Madison, an 1803. This is sort of an original case. Quote, "This is the Supreme Court, and by reason of its supremacy must have the superintendence of the inferior tribunals and officers, whether judicial or ministerial. The Supreme Court or any other court of appellate jurisdiction may affirm, modify, vacate, set aside, or reverse any judgment, decree, or order of a court lawfully brought before it for review. For this reason, plaintiff's observation that the Second Circuit may have provided a different result prior to Fourth Estate is of no moment. When matters are decided by an appellate court, its rulings, unless reversed by it or a superior court, bind the lower court. It is axiomatic that in our judicial hierarchy, the decisions of the circuit courts of appeals bind the district courts, just as decisions of the Supreme Court bind the circuit courts." So That means that a Supreme Court decision eliminates all of that dispute, even somewhat retroactively to existing cases that were going on at the time. Just because they filed when the Supreme Court hadn't made a decision yet doesn't mean that the decision doesn't apply to them retroactively, which is a bit unfair. I'm not saying that that's not unfair. It's just not illegal. It's how the law of Supreme Court precedent and appellate court precedent works. Moreover, the court declines to grant plaintiff leave to amend the complaint to allege registration should its copyright application be approved in the future. So the court's not even giving them a chance to hold or stay the case and then restart, not having to pay a new filing fee, not having to file a new complaint, not having to start over. The court declines to allow them to do that. On this issue, the court finds that Malibu Media versus Doe. I'm one of the attorneys that fights Malibu Media, so that's really interesting. They find that case persuasive from April 2nd, 2019. The case presented the question of whether a plaintiff that improperly filed suit before a copyright was registered could cure that defect by amending its complaint after the register has completed registration of the copyright. The court answered that question in the negative, reasoning as follows. Plaintiff's argument would make meaningless the formality of Fourth Estate's requirement that an application be approved prior to filing suit. Were it correct, a plaintiff could file suit at any time, notwithstanding Section 411A, and simply update the complaint when registration finally occurred. That would undermine Congress's choice to maintain registration as a prerequisite. Enforcing Congress's choice means that an amended complaint alleging compliance with Section 411A cannot relate back to a time before the compliance was achieved. By the same token, accepting the amended complaint as though it instituted a new action for purposes of Section 411A will not do. Even though it would save plaintiff the trouble of refiling, seeking leave to serve another third-party subpoena, perhaps defending a new motion to quash, and paying another filing fee, indeed doing so would fly in the face of 411A's text, which provides that registration must be complete before a civil action is instituted, and would defeat Congress's purpose to maintain registration as a prerequisite to suit, not just to liability. Accordingly, plaintiff's direct copyright infringement claim is dismissed for failure to state a claim. One who, with knowledge of the infringing activity, induces, causes, or materially contributes to the infringing conduct of another may be held as a contributory infringer. Having determined above that plaintiff cannot sufficiently plead direct infringement, it can't state a claim for contributory infringement either. So for the reasons set forth above, Pamela K. Chen, United States District Court Judge, holds that defendant's motion to dismiss is granted in its entirety. Now that, I don't think that means they can't file a new complaint. I don't think this is considered adjudicated on the merits, and therefore the plaintiff couldn't refile once they have a copyright registration. But it does mean that this entire complaint and effort gets dismissed. And if Gigi Hadid and her lawyers wanted to go after a motion for attorney's fees and costs, they probably can do so. I believe this was answered. Even if it wasn't answered, there's some case precedent that the Section 505 of the Copyright Act that shifts fees back to or against the losing party and for the prevailing party, that might apply even if a motion to dismiss was granted before an answer was filed or anything like that. So it depends on how much she wants to pursue that sort of small amount of money for her. She's one of the highest paid supermodels in the world, if not the highest paid. So not saying she can't choose for herself whether a few $1,000s to her attorneys, well, maybe they took a little bit, with their Fifth Avenue attorneys, maybe they took a lot more than a few $1,000s. But that money might be a drop in the bucket for her and not worth pursuing. On the other hand, the photographer does have a legitimate copyright claim. They're just not allowed to file it till they have that registration in place. And then maybe they do have a copyright claim, so maybe you don't go after them for the fees and costs. Maybe you try and settle the matter now so that they don't just refile later. If Gigi Hadid and her lawyers went after exclusively for the cost of the thing, maybe exclusively would be more apt to go after Gigi Hadid once they had a valid copyright. Be careful there, I guess. What do you think of that?
I feel a little bit bad for the plaintiff, because at the time of filing the case in that area, they were allowed to file. They were allowed to file the lawsuit as long as they had started the process of registering the copyright. And then the Supreme Court case came down, and so it's like, okay, they did everything in good faith. They weren't psychic. They didn't know how the Supreme Court case was going to go. And now they're kind of being penalized for that. But I also understand the court's reasoning that they can't just ignore the Supreme Court. Like, no, you have to follow the Supreme Court.
Yeah, note here how important it is for the judge or the court to identify Congress's intent in creating the law and honor that, not just find some loophole around the black letter law, but rather also look at the intent of the legislature or the lawmaking body, which is elected by the people, and laws must pass bicameralism. You must pass the House and the Senate and be signed by the president, or pass the House and the Senate by a 2/3 supermajority, and then become law. So the court honors that law as best as it possibly can. If there's ambiguity, the judges generally try to find any legislative intent that can resolve the ambiguity and go from there. If there's truly ambiguity, then we rely on things like plain meaning or accepted meaning in the circumstances, and other things like dictionary definitions, etc. So, but if there's legislative intent or there's history there, then you look at that, and that's exactly what the court did here, and says, well, the intent is to require a registration. Same thing that the Supreme Court said. So we can't go against the Supreme Court, and Supreme Court can't go against Congress. What the Supreme Court can do is interpret the law and the Constitution, and Congress can try to make a law or successfully make a law that goes against other laws or maybe the Constitution, and then the Supreme Court or an appellate court or district court or whatever court has to resolve that and say, well, does the Constitution win or does the new law win? If the new law was passed as an amendment to the Constitution, then maybe that would win. But we don't really have too much of that these days. Congress is busy doing other things. We can have that conversation, not on lawful masses. I guess I don't understand why exclusively. I guess it's because they filed the thing early, because they filed the thing while Fourth Estate was still going on, and second, and they didn't realize or plan for the Fourth Estate case to resolve that way.
Yeah. Plus, what my question was, yesterday when we saw this, why didn't his lawyer ask for a delay to file the registration? Apparently, they're not even allowed to adjust the complaint.
Yeah. So the court did give us good reasoning there. The court really can't allow them to amend the complaint, even if it wanted to. Normally, the court would allow you to amend the complaint, and you do have is it Rule 15? I think it's Rule 15. You have usually the plaintiff has the right to amend the complaint once without permission.
It still feels a bit harsh that you can't amend it because the law actually didn't change. It's just the interpretation got set straight, but
right.
Still.
So there's a reason. So the court's reasoning there was something that you might not have noticed, because who would notice that the words relate back are a key word or a special term? So there's a doctrine of relation back in the law, and when this doctrine applies, so for example, I just mentioned an amended complaint. Well, the original complaint should have put Gigi Hadid in this case on notice that a copyright claim has been filed. So if there's something wrong with the complaint that can be resolved or be cured and allow the complaint to continue on the merits, normally a judge would allow that. And normally the Federal Rules of Civil Procedure would allow Gigi Hadid to answer the complaint and maybe even point out, or maybe even make a motion to dismiss and say, this should be dismissed or this is invalid. And then we can file a second complaint called a first amended complaint, or just an amended complaint for the first one. And then you'll see second amended complaint, third amended complaint. You don't really get much very, very far past there. If you can't resolve your complaint issue by the third or fourth time, I don't think I've ever seen a fourth, or I've definitely never seen a fifth amended complaint. I'm sure they're out there. I'm not saying it doesn't exist. But so you amend the complaint once as a matter of course without permission, then the defendant has to start over. They already have a document created, they've already got an answer, and your amended complaint really isn't going to be that different, right? So they just have to answer it again with the new, whatever the new allegation is, or new, or correction, or whatever. So normally that would relate back, since the plaintiff filed the thing and put the defendant on notice, then refiling or changing the complaint to something similar. As long as it's similar enough, it should relate back because they're already on notice of the previous thing. What the judge is saying here is because Congress required a required registration before instituting the action at all, the judge would be bound not to relate that back because that requirement was not met at the time that it was filed. And so your complaint would really be from the new time, and that violates Congress's intent. It's not that the copyright claim in fact is not valid. You can still sue for those copyrights, and the in-between time is not necessarily like a freebie for a defendant. It's just that you can't sue until you get that piece of paper from the Copyright Office, or at least the approval that the application has been granted a, like for performing arts, for like a video, it would be a PA number. I'm sure there's other, I forget what all the prefixes are, but you get an actual number and then you can sue. All right, so that is our show, everyone. Thank you for joining me. I am Leonard French, your favorite copyright attorney, and joining me in the studio today has been Kaylee, as well as Tactical and Brandon in the virtual studio. Thank you to our supporters on Patreon and sponsors. At the $500 level, we have a $500 supporter, Joshua Davis from TandaPay. In the month of July, we'll be going over his social insurance program that is dependent, it appears, to be using the blockchain technology for some actual functional purpose, which is really cool. I'm looking forward to seeing that. Thank you to our $50 plus supporters in July: John Steele, Gavin Barnard, Kyle Mudrak, Eevi, Michael Pearce, Richard Fournier, Spirit Bear, Jan Negrey, Daniel Perez, and Snorre Wisotzky. And thank you to the $5 plus supporters who are scrolling on the LED panel behind me and in the description, with the $50 plus supporters and the $500 supporter as well. So I'll have some dog video for you here for the outro, of course. Actually, here is a dog. Here is the dog.
Shark.
Okay, so that's our show. Love you all. Have a good Sunday and a good week, and I'll see you in the videos that drop. I'm Leonard French, your favorite copyright attorney.
Bye.
Bye.
Bye.